Hello, I am Ritesh Kumar, Assistant Professor in Mechanical Engineering Department from Engineering College, Jhalawad, Rajasthan. Today I will discuss topic Information Technology Act 2000 under Unit 3 in subject Laws for Engineers from our RTU syllabus. In this topic, I will discuss about Information Technology Act, then objective, then chapter of this act and advantage of this act. First of all, go through introduction. The information technology is an application of computer and telecommunication equipment to store, retrieve, transmit and manipulate data, often in the context of a business or other enterprises. This Information Technology Act 2000 is an act of the Indian Parliament notified on 17th October 2000. It is primary law in India dealing with cybercrime and electronic commerce. Information technology is one of the important law relating to Indian cyber law. It had passed in Indian Parliament in 2000. It consists of 13 chapter, 94 section and 4 schedules. This act is helpful to promote business with the help of internet. It also set up rule and regulation which apply on an electronic business transaction. It is based on United Nations Model Law on Electronic Commerce 1996, known as UNCITRAL model, recommended by the General Assembly of United Nations by a resolution dated 30th January 1997. Due to increasing crime in cyberspace, Government of India understood the problems of internet users, and for safeguarding the interest of internet users, this act was made. Objective Objective of IT Act 2000 to give legal recognition to any transaction which is done by electronic way or use of internet, to give legal recognition to digital signature for accepting any agreement via computer, to provide facility of filling document online relating to school admission or registration in employment exchange. According to this act, any company can store their data in electronic storage to stop computer crime and protect privacy of internet users, to make more power to IPO, RBI and Indian Evidence Act for resisting electronic crimes. In this act, there four set of rules have been introduced under this act. First, reasonable security practices and procedure and sensitive personal data and information rule. In this rule, provide procedure for collecting and storing sensitive personal data and information. Short, it's known as SPDI. SPDI may be shared only with prior consent of the individual. SPDI may be shared with government agency on a written request for the purpose of investigation, prevention, prosecution and punishment of offence. Second rule is Intermediary Guideline Rule 2011. In this rule, intermediary are as those who provide internet, telecom, email or blogging service and include cyber cafe. It is not liable for any content hosted or transmitted through it by users. Intermediaries are required to comply with due diligence standard and to remove unlawful contents upon receiving actual knowledge. Third is Cyber Cafe Rule 2011. The Act empowers the government to prescribe standards for intermediaries, including cyber cafe. If a cyber cafe does not comply with the rule, it would be liable for any misuse by the customer. Under this rule, all the cyber cafes have to register with registration agency notified by government. Fourth, Electronic Service Delivery Rule 2011. In this act, authorizes the government to take a step to provide for electronic delivery of service such as filing of income tax return, application for passport, payment of tax. This rule empower the government to notify service to be delivered electronically and the signing authority for different permits. The government may also notify entities that shall provide access to service. Now there are total 13 chapters. In this chapter first contains two sections, section 1 and section 2. Chapter first saying about preliminary. In this short title, extent, commencement and application definition are described. Chapter 2 say that any contract which is done by subscriber, if he sign the electronic agreement by digital signature, then it will be valid. Chapter 3 have this chapter explain the detail that all electronics record of government are acceptable unless any other law has any rule regarding written or printed record. About chapter 4 say that attribution, acknowledgement and dispatch of electronic record. There in this total 3 sections, section 11, section 12, section 13. Section 11 attribution of electronic record, section 12 acknowledgement of receipt, section 13 time and place of dispatch and receipt of electronic record. Chapter 5 says secure electronics record and secure electronic signature. In this have also 3 sections, section 14, section 15, section 16. Section 14 says secure electronic record, 15 says secure electronic signature and 16 security procedure and practice. Chapter 6 about regulation of certifying authority. In this have section 17, 18, 19, 20, 21, 22, 23, 24, 25, 26 to 34. In this chapter states that Government of India will appoint controller of certifying authority and he will control all activity of certifying authority. Certifying authority is that authority to issue digital signature certificate. Chapter 7 say that electronic signature certificate. In this have section 35 to 39. Certifying authority to issue electronic signature certificate, representation upon issue of digital signature certificate, suspension of digital signature certificate, revocation of digital signature certificate and notice of suspension or revocation. Chapter 8 describe duties of subscribers. In this generating KPR, duties of subscriber of electronic signature certificate, acceptance of digital signature certificate, control of private key. Chapter 9 about penalties, compensation and adjudication. In this penalty and compensation for damage to computer system, compensation for failure to protect data, penalty for failure to furnish information, residuary penalty, etc. Chapter 10 about the appellate tribunal. In this there is section 48 to 64. Chapter 11 about offences. In this section, have section 65 to 78. For controlling cyber crime, government can appoint cyber regulation advisory committee who will check all cyber crime relating to publishing other information. If any fault is done by anybody, he will be responsible for paying Rs 2 lakh or he can get punishment of 3 years living in jail, or both precision penalty can be given to the cyber criminal. About chapter 12 intermediaries, intermediaries not to be liable in certain cases. In this exemption from liability of intermediary in certain cases. And Chapter 13 has miscellaneous in this from section 80 to 94. In this, power of police officers and other officers to enter search etc. Act to have overriding effect, application of the act to electronic check and truncated check, controller, deputy controller and assistant controller to be public servants, power to give in direction, protection of action taken in good faith, etc. Now I will go to advantage of IT Act. Advantages are helpful to promote e-commerce, enhance the corporate business, high penalty for cybercrime, filling online for. Thank you.